Good morning. We are so excited to be here in Berkeley Springs in Morgan County this morning. And being a lifelong Girl Scout, I've asked some Girl Scouts to help us open today with a flag ceremony. And I believe it's troop 40764. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. On my honor, I will try to serve God and my country at all times, and to live by the Girl Scout law. Thank you, ladies. So before we begin with the first case, I'll just say a word or two. There are two reasons we're here today in Berkeley Springs. One is that we were going to come last year and we're unable to because of a variety of circumstances. And so I felt kind of bad about that. But the second reason is I got to choose where we were going. And I tried my very first jury trial in Morgan County as a young lawyer. Thanks to Judge Lawrenson, who did the research for me, I figured out it was in the summer of 1995. So 25 years ago, I was in the old courthouse getting ready for a trial later in the year. So I thought it would be fun to come back. So thanks for the opportunity. And will the clerk please call the first case?
Yes, Chief. The first case for oral argument today will be argued under Rule 20 of the Rules of Appellate Procedure. Christopher J. versus Donnie Ames, the superintendent, docket number 170994.
May it please the Court, Chief Justice, Justices, Mr. Ellis, Daniel Kirkland on behalf of the petitioner, Christopher J. Prior to beginning my argument with the Court, I'd like a brief recitation of the facts.
That would be great.
In November of 2007, the petitioner, Christopher J., was asked to babysit two minor children, WT and JT. At the time of the alleged offense, Christopher J. was 16 years of age. The young children, JT and WT and JT were 4 and 3, respectively. At the end of the night, petitioner was taken home by the minor children's parents. At that time, the mother did notice that the house was in disarray, that there was ketchup on a decorative towel. Nothing else was said that evening. Following that, about 5 years later, in 2012, one of the minor children, WT, indicated to his father, without any request or any indication as to why, that he would not like the petitioner, Christopher J., to ever babysit him again. That caused some concern for the father, who then asked further questions, and at that point, WT, the older of the children, indicated that during the time he was babysitting in 2012, Christopher J. Had forced him to perform oral sex in a bathroom. Following that, Christopher J., petitioner, was charged through juvenile petition with 2 counts of first-degree sexual assault and 2 counts of sexual abuse by a custodian. A transfer hearing was held, at which time he was transferred to the adult criminal status of the court. At this time, the petitioner was roughly 20 to 21 years of age, but at the time of the offense, he had just turned 16. He was subsequently indicted on similar charges with the same exact charges and proceeded to a jury trial with the Honorable Christopher Wilkes presiding. During the course of that trial, numerous witnesses were called, including the 2 minor children, WT and JT, who at this point were 9 and 8 respectively. At the conclusion of that jury trial, the petitioner was convicted on 1 count of sexual assault in the first degree related to WT, the older of the 2 children, and 2 counts of sexual abuse by a custodian, but was acquitted on the sexual assault count related to JT, who was 3 years old at the time of the offense. Now, the primary issue before this court today is the retroactivity of West Virginia Codes 611123 and 621213BA. And for 3 logical, evidence-based reasons, this court should make a finding that those are in fact retroactive. In this case, the petitioner did not get the benefit of those statutes because he was sentenced about 10 months before the effective date of June 6, 2014. And just to kind of indicate what that statute does is that it takes an aggregate sentence in the case of the petitioner who received a 35 to 75-year sentence. All of his charges were run consecutive, which means he is not eligible for any opportunity at parole until 35 years has elapsed. Now, West Virginia Code 611123B would basically shorten that time for parole eligibility. It does not mean that he is released, but it will ensure that he has a meaningful opportunity at parole after 15 years. So it will effectively take off about 20 years until he's parole eligible. That particular code, along with 621213BA, was passed as a comprehensive restructuring and amendment to the juvenile sentencing in this state. And it followed numerous Supreme Court cases, Roper, Graham, and Miller. And the central intuition of those cases is that children, minors who commit crimes, are distinctly different from their adult counterparts. That's not a hunch. That's not just a gut feeling. That is based on empirical data gathered over a period of 20 years that minors are impulsive. They do not understand consequences. They do not have the ability to formulate the risk from their actions. Now, this particular code being passed, following all of that empirical data, it serves to fix a problem, a national problem, a problem that's been recognized on a national level, that sentencing schemes for juveniles are too harsh, that they fail to take into account the differences between adult offenders and children. And that's effectively what the petitioner was. He was a 16-year-old male at the time of these offenses. So the public policy is that we will not treat children the same. And West Virginia answered that by passing this statute. But not only does public policy support retroactivity, not only does it support fixing that problem with juvenile sentencing, but the clear words of the statute do as well. If we look at the statute, particularly the subsection D, the statute's comprised of several different things. First, it deals with, subsection A deals with life sentences, whether or not a juvenile offender may be sentenced to life without mercy. That statute prohibits that. Subsection B deals with aggregate sentence exceeding 15 years. Subsection C deals with certain factors a circuit court must consider prior to the imposition of a sentence. And then subsection D goes further with that and deals with in-depth family interviews, peer interviews. But subsection D2 expressly makes subsection D not retroactive. It essentially says that that particular subsection, and that subsection alone, only deals with sentences after the effective date. And shifting back to the public policy.
Well, this is perhaps a better argument than retroactivity, is this particular statute doesn't so much deal with sentencing as it does parole eligibility.
And it does, Your Honor. It specifically references parole eligibility in Section B. And it also references 621213BA, which is the controlling statute on the parole eligibility of juveniles convicted as adults. And both statutes reference one another. And if we look at 621213B, it actually says when a person who is serving. So the effective date of passage, the language contained in this statute, seems to indicate that anyone serving a sentence at the time of passage would be entitled to the benefits of that statute.
That's why I don't think retroactivity is, that seems to be the focus of your primary argument, but maybe that's more of an uphill battle than the present argument.
The retroactivity, or whether or not it just simply applies to parole eligibility?
I mean, I think it could be argued, I haven't formed an opinion on this because we're still hearing argument, but it could be argued that this statute deals strictly with parole eligibility, and the time hasn't come yet under either scenario for your client to be eligible for parole, but the argument could be made that this is the statute that kicks in when he is.
Absolutely, Your Honor, and the problem with that is we're going to presume that the parole board is going to follow that statute with any guidance from this court. If that was the case, you know, in case of the petitioner, if you look at his DOC file, it says that he is not eligible for parole until 2047, which is actually 35 years following his offense date, his sentencing date. So that in itself doesn't indicate the parole board is actually implementing this policy as retroactive. So I think simply relying on a future assessment and whether or not the parole board does it could create problems down the road when we can fix this now.
Well, I mean, but you're asking us to address it. It's going to be addressed one way or the other.
Yes, Your Honor, and what I'm doing is asking the court to address it and to find that the provisions of 611123 and 621213B are retroactive and would apply to juvenile sentences adults prior to the effective date of this sentencing.
Well, counsel, how would you calculate the parole eligibility date? I think you've obviously just stated that from his file it suggests the 35 years that he's not eligible. Does that contemplate his eligibility for parole, good time, and other factors that could be calculated in? Or what do you think the appropriate parole eligibility date should be?
Well, first, it's 35 years is his earliest date available for parole under the current sentencing order. He received an indeterminate 35 to 75 years, which means he's looking at 35 till he's parole eligible and roughly 37 and a half until it's discharged. If the statute were to be applied retroactively to his case, he would be parole eligible in roughly 2027, 15 years. And that doesn't mean he's going to be released. What it means is that he will be guaranteed a meaningful opportunity at parole, at which time the parole board will follow this statute and will implement all of the things they have to do in order to determine whether or not he is fit to be released into society.
With regard to the issue of retroactivity, we have a number of legislators here today. You said at the outset the legislature, obviously in their sentencing reforms, they chose not to provide retroactivity of this particular section. So you can see that statutorily retroactivity is not provided for.
I disagree. Now, are there, under the current law, there must be clear operative words or necessary implication which makes that retroactive, and I think under either scenario we can meet that. First, this was passed as a result of comprehensive data collected on juveniles, their ability to understand the risk, and whether or not, simply put, that we should be treating 16-year-old offenders the same as we should be treating adult offenders.
I understand. My question was 611123B does not provide for retroactivity, does it? Specifically.
D. Is that what you said? I'm sorry.
B.
B, yes.
Does it expressly say within the context of that statute that it is retroactive? No. But if we look at what I would say the intent of the legislature in passing sentencing reform, it would seem illogical to me and make little sense that we would take an effective date, okay, June 6, 2014. A juvenile in the same position sentenced June 5th of 2014 will serve 35 years before he is parole eligible. That same similarly situated juvenile sentenced June 7th of 2014 will have 20 years taken off that sentence. I don't think the legislature intended for that kind of logic, that we're going to pass a comprehensive reform to juvenile sentencing, but we're going to exclude people based upon an arbitrary number. This was a response to an overwhelming national consensus that we should not treat juveniles the same.
But aren't we limited to the express language of the statute? We do occasionally have the opportunity to look at statutes that make little sense, and it's not really our province to legislate. So how do we get around the fact that the legislature chose not to specifically say so? I understand your policy argument, but for what I'm having a little trouble getting around the absence of the language.
Okay, so let's take the words out of it and look at the necessary implication then. Let's look at the policy behind it. I think that in itself would support retroactivity, but then let's look at the language of the statute as well. Why would they make one provision of this statute, subsection D2, expressly not retroactive if they did not intend for it to be retroactive as a whole? Second, look at 62.12.13b when it says is serving. Is serving, those operative words seem to imply retroactivity. They seem to imply that if you were serving a sentence as a juvenile offender, convicted as an adult at the time of passage, then this will apply to you. You will be entitled to the benefit of parole eligibility. And then we can...
Isn't it a lot, aren't you making essentially a logical argument that one section of this statute says it's not retroactive? Therefore, logically, the implication would be that everything else not included in that subsection D would be retroactive. I mean, isn't that the natural, logical step you're trying to take?
It is, Justice Hutchison. That's the exact step. And maybe I'm not doing it quite as artfully, but...
Well, I wouldn't say that was artful, guys.
I wouldn't understand the logic in making one part retroactive if you didn't intend for the whole to be retroactive. That, coupled with public policy, seems to support the necessary implication of this statute would support retroactivity.
But isn't Section D, though, D2, really designed, as I read it, not necessarily, even though the effect may be retroactive, it's just basically saying we're not going to reopen every case simply because there wasn't the mental health evaluation that was provided for in D1. That's basically all it's saying. It's not necessarily saying that the whole section is going to be applied retroactively. It's just saying that these evaluations that are required under D1 are not going, simply because you didn't have one, that's not going to reopen every case. Isn't that basically what the statute's saying? Not necessarily that the whole statute's going to be retroactive or isn't retroactive, but simply the mere fact that we didn't have an evaluation is not going to.
It is, but what would be the need to clarify that if the entire statute was prospective? Because you wouldn't be entitled to the benefit retroactive anyway. So it doesn't make sense they would do that. But I suppose it could be subject to differing interpretations. The entire statute probably could. And in that case, you know, this court could choose to apply the rule of lenity in an ambiguous statute, and whether or not it is truly retroactive. And under that, it would be in favor of the defendant.
Well, I think we understand your position. I'll give you an opportunity to provide a rebuttal. Let's hear from the state.
Yes, Your Honor.
May it please the Court, Chief Justice Walker, I'm Caleb Ellis. I'm an Assistant Attorney General on behalf of the respondent. Section 611123B should not be construed retroactively, precisely for the reasons this Court has been discussing. There's no language in the statute that indicates retroactivity, and both by statute and by this Court's decisions, it's been recognized that when a statute doesn't specifically provide for retroactive effect, it will be applied prospectively only. And lest we think the legislature doesn't, they know how to make this clear. For instance, statute that's inapplicable to this case but dealing with sex offender registration, 1512(2)A, specifically provides that provisions of this article shall apply retroactively and prospectively. So the legislature absolutely understands how to make a section retroactive when they want to do so. Now, as far as the other sections that are tied in with subsection B, which is, for instance, 611123D2, doesn't actually address the issue of retroactivity. What that says is it says that provisions of this subsection shall only apply to sentencing proceedings for convictions rendered after the date of this section and not reconsideration proceedings for convictions rendered after the effective date of this section. So it doesn't deal with convictions rendered before this subsection at all. It just says these are for sentencing, not for reconsideration proceedings. So the idea that that should somehow be read to say, well, this subsection is not retroactive, so therefore the other ones are, just doesn't make any sense because that section doesn't deal with retroactivity. As far as what we might consider the companion statute of 621213B, which has the language, yes, when a person is serving a sentence imposed as a result of an offense or offenses committed under the age of 18, becomes eligible for parole pursuant to applicable provisions of this code, including but not limited to 611123. Then certain procedures have to happen because they were, a juvenile when they were convicted. Relying on that to say that 611123B is retroactive is somewhat of a circular argument. Sure, 611213B says when a person who is serving. So the respondent has no problem with the idea that that subsection is retroactive, but it only kicks in when someone becomes eligible under an applicable section. But as in petitioner's case, 611123 is inapplicable because it came into effect after his sentencing.
Now, how old will the juvenile, he'll be an adult, of course, but how old will he be when the sentence is completed as far as parole eligibility?
My understanding is that in 2047, he will be 56 years old. He was born in 1991.
Which is very young.
It depends on your perspective on that. It used to seem old. It's probably very, if you're in prison, it's probably a long time. What about the whole, this is looking at the larger issue. If you look at the legislation on juvenile delinquency, the whole thread and tenor of it is, and it has been for quite a while, enunciated in the statute as designed to be rehabilitative, to be remedial as possible, and it appears to recognize that juveniles basically should be treated different than adults. But here he was transferred to adult status. Do you think that those concepts still should be observed?
In terms of the overall, in terms of like the Supreme Court's cases and things like just the overall bent, yes, I think that those have to, the subsection shouldn't be retroactive, but in terms of considering that he was younger when he committed the offenses, the majority of cases in other jurisdictions that look at people who committed even what are considered adult offenses when they were younger and were sentenced to incarceration still have considered that they were younger when they committed the offenses. Does that answer your question?
I think it does, and I appreciate your honesty on that. Does this case fall within the Graham v. Florida United States Supreme Court case?
No, Justice Workman, and there's several reasons for that. number one, and this, of course, is not your question, but it hasn't been raised or argued, and it could have been raised on direct appeal. We're talking about retroactivity of a statute because the statute was passed in 2014. Graham was decided in 2010. That could have been dealt with on direct appeal if petitioner wished to argue that that was applicable to his case. But as to the substance, Graham dealt specifically with a life without parole sentence, and it looked at that as that is a special that is a specific type of sentence, a life sentence. Petitioner here has not been sentenced to life without parole. He's been sentenced to a term of years based on actually 3 sentences, not just one. It's an aggregate of 3 consecutive sentences. Now, I will be.
But isn't this statute effectively a result of Graham? The state of West Virginia had to come up with some sort of plan, because Graham doesn't say 15 years. West Virginia has said we're going to say that the period of time that he's got to serve is 15 years. So the first part of 611123 talks about life sentence, but the state of West Virginia has recognized, have they not, in going into subsection B, that there are times whenever juveniles can be incarcerated under other circumstances that takes them beyond the 15 years. So why would you treat somebody who has an aggregate sentence that takes them longer than 15 years differently than you would treat somebody that had a life without parole? And you're saying, okay, this is because he was a juvenile when the crime was committed, we're going to say 15 years, he gets a meaningful opportunity to talk about parole. Why would you treat the two differently and not make those retroactive?
Well, Justice Hutchinson, this is kind of where I was going. Some jurisdictions have extended Graham to long life sentence, or not long life sentence, long term of year sentences based on aggregate sentences. It's pretty split right now among high state courts and courts of appeals on whether Graham, in the companion case of Miller, which deals with life without parole for homicide offenders, and that's not as applicable here. Some courts have held that those do extend to long term of year sentences. Some have held that they haven't. However, where the courts have held that those cases do apply, they've done under what's considered a de facto life without parole. And no court has held that a 35-year sentence or a 35-year parole eligibility, because a lot of what they look at in terms of whether it's a de facto life without parole is when parole eligibility happens. And the tendency is about 50 years is kind of the break line where courts, the most protective courts who have said that the least lowest sentences that courts have said are de facto life without parole has been parole eligibility in about 50 years. For instance, Pennsylvania held that a 30-year to life sentence with obviously parole eligibility in 30 years was not a de facto life without parole sentence. So in petitioner's case particularly, the protections of Graham don't apply because even if this court were to eventually say Graham should apply to long term of year sentences based on aggregate consecutive sentencing, it wouldn't apply to petitioner's case because he has a meaningful opportunity for parole.
But the state of West Virginia has already said that. Okay. The state of West Virginia has said in this statute, at least prospectively, that anything that an aggregate sentence that's anything longer than 15 years is going to kick in a review at the end of 15. That's what this statute says prospectively. Is that right?
Correct.
Well, so now the question is, why would we treat somebody that was convicted of exactly the same circumstances after the effective date of this statute? Why would we treat them differently, recognizing that juveniles should be treated differently? We look to rehabilitation and that sort of stuff. Why should we treat them differently than somebody that was sentenced a month before the effective date of this statute?
Well, this court has recognized that the rules for judicial decisions retroactivity and statutory retroactivity are different. Graham and Miller are retroactive because under constitutional rules, when the Supreme Court announces a new rule of substantive constitutional interpretation, it should be applied retroactively. And they've decided that about Miller, and some circuit courts have said that about Graham. And respondent has no question about those applying retroactively, but the statute goes further. The West Virginia 611123B goes further than those decisions do, much further, in fact. And so that section is not controlled. As far as the logic of why the legislature didn't want to put in a provision that specifically says it should be retroactive, I'm not exactly sure. But that's their decision to decide whether something should be retroactive or not.
What I inarticulately asked earlier, I think might be in the same vein of what Justice Hutchison is asking, and that is, why do you even have to get to retroactivity? If this statute applies prospectively, then would it not provide parole eligibility under the new statute rather than the old one? Because the parole eligibility issue, the issue's here, but the date is still up in the air. So why would this statute have to be retroactive? Couldn't it just apply prospectively to this man's benefit?
To anybody that is serving.
No, Justice Workman, I apologize. Because parole eligibility is calculated based on your sentencing date and based on the laws that are in place at the time. For instance, in Adkins versus Bordenkircher, case dealing with good time credit, but relying a lot on law related to parole eligibility, this court recognized that a change in law to good time credit that operated, that essentially changed good time credits to the detriment of prisoners would be applied retroactively if it were applied to prisoners already serving. Under those principles, for instance, if the state changed the provisions for parole and how it's calculated to the detriment of a prisoner already serving, based on convictions, past convictions, there's no question we'd be sitting here discussing an ex post facto issue right now. Of course, we're not, because the change is theoretically beneficial if it were to apply.
Counsel, is there any reason that the legislature submitting knowledge that specifically 611123B does not provide for retroactivity specifically? Isn't the legislature capable of going and passing a law signed by the governor that would apply the provisions of retroactivity, and this petitioner and others similarly situated would benefit from that statutory change?
Yes, it could do that. The legislature could pass a statute that says...
That's my issue of, again, looking at what the law says that the legislature crafted, or is it our role, per the petitioner's suggestion, of taking in the body of research and evidence? That's what the legislature does. They have the ability to formulate the statutory law and that we interpret. And we're provided with a provision that does not apply for retroactivity in its specific wording, and being asked to write that into the law.
Absolutely. Respondent totally agrees with that, Justice Jenkins. There was an argument about what is the reason for this? Why should this apply to people convicted?
It's a legislative responsibility, is it not?
Exactly.
You must have said something wrong.
Whoops. It's quite a question, Justice Jenkins.
Somebody actually didn't like it.
So, yes, it's the legislature's prerogative, and while there may be reasonable minds might disagree about whether this should have been retroactive, other people, had they been in the legislature, might have wanted to put that provision in. It's not the place of the court to rewrite that because it may seem more fair.
But what about petitioner's argument that it's not fair, essentially, that someone who's sentenced on June 5th would not enjoy the benefit of the statute, and someone sentenced on June 7th, 2 days later, would?
Well, that's not any... that would apply to any sort of change in a statute that would be beneficial to. Effectively, that argument would rewrite the rules of retroactivity. That would flip the presumption, because if a law is changed, and it applied differently to one series of people before and one after, that is by definition unfair. So to use that as a principle to cut against retroactivity would be to essentially flip the presumptions with regard to retroactivity itself.
It seems to me that under the statute, because the legislature was to some degree responding to Graham or the cases relating to Graham, to ensure the meaningful opportunity for parole. If your client didn't have any opportunity, then perhaps there would be a problem here. But under this statute, isn't your client still assured a meaningful opportunity for parole? It's not that your client or I'm sorry, not your client, but the petitioner here. If they had not had any opportunity for parole, then there might be a Graham issue here. But is there really a Graham issue here if the statute still provides an opportunity for parole, even though it's a longer period?
No, there's no Graham issue here. Graham hasn't been directly argued, but had it been, the first issue we'd have to decide, well, the court could decide, one, does Graham apply to aggregate consecutive sentences? And as I said, it's very split. Many courts have held that it does. Many have held that it doesn't. But it would also have to decide, is this a de facto life without parole sentence? And as I think you alluded to in your question, this is not his sentence, even with the 35-year eligibility. That's not long enough under the courts that have interpreted Graham and Miller to count as a de facto life without parole, even if the court accepted the applicability of Graham to consecutive sentencing for long periods of time. So no, there is no Graham issue.
If there's not a Graham issue, then we just read a statute. Isn't that what we're called upon to do? And if the legislature had wanted to make it retroactive, as it's been discussed, it could have.
That's correct.
Well, if we read the statute as written, and you have to read it in conjunction with the other statute, what is it, 62-12-13. 62-12-13 says currently is serving, right?
Correct.
Well, then if you read that statute in conjunction with this, it says retroactivity is not an issue. We just apply this statute to the sentence that anybody is serving, to somebody that is serving, which may mean that we have to go back and look at it and say, oops, this guy is not eligible till 2047, but because of this statute, we now have to recalculate and drop him to 15 years. Isn't that what that statute says?
No, Justice Hutchinson. Now, respondent has no problem necessarily with the idea that 62-12-13B and the considerations that are provided therein in terms of the actual procedure once parole eligibility comes up, that those have to be observed in petitioner's case, because as you stated, the language is when a person who is serving. However, it also includes language that says when a person becomes eligible for parole pursuant to applicable provisions of this code, including but not limited to 61-11-23. And 61-11-23 is not applicable. He will become eligible for parole under the standard provisions of applying to parole.
Why would it not be applicable? Because it is in effect at the time we're taking a look at this case. So why would 61-11-23 not be applicable to determining when his eligibility for a meaningful parole hearing would come up? Why would it not be applicable?
Because it was not in place at the time of the offenses in 2007 or at the time of his conviction and sentencing in 2013.
All right, I think we've got it. How about a brief rebuttal?
Just to hit on Graham, I'm not alleging a violation of Graham. Graham deals with a mandatory life sentence in the absence of homicide. So it's a non-homicide case. That is the basic function of Graham. That's the sentence Graham deals with. But that's looking at it very narrowly, because what Graham truly is and what Miller truly are, and even Roper, is there a substantive rule that children are different, that we should treat them differently than adult offenders. And based upon that logic and that rule set forth in those cases, the series of Supreme Court cases, the West Virginia legislature, as numerous other legislatures around this country, Connecticut, Massachusetts, Arkansas, California, responded. And West Virginia responded in probably one of the most comprehensive manners. So it took the floor of Graham and it went beyond that. And it said, we're going to put 15 years in homicide cases until you have the meaningful opportunity at parole. And in non-life cases, we're going to set a max the same way, 15 years. And we're going to guarantee you a meaningful opportunity at parole. Not release, not discharge, but an opportunity to meet the functions of Graham and Miller, which is children can be rehabilitated. That we should not lock them away and throw away the key.
Now, does that still stand, that principle, since he was transferred to adult status, even though he was a juvenile?
It does, Your Honor, and I think what all of those is, it's at the time of the offense. Those are the factors you would have to consider: the impulsiveness, the lack of ability to take risk. They're at a juvenile level at 16, 17. So yes, I think regardless of the offense date, if the offense was committed while under the age of 18, this statute applies. In the petitioner's case, he was 16 years old. It should apply to him. Merely missing by 10 months the benefit of this statute is illogical. It does not make sense. That is what the legislature intended when they responded to the foundation set forth in Graham and Miller. Thank you.
Thank you both. This case will be submitted.
Moving now to the Rule 19 argument docket. Robert Smith, administrator of the estate of Aspen Smith versus Dr. Carolyn Clark and Cabell Huntington Hospital. Docket number 17-1086.
And I neglected to do so at the beginning, but I'll say this before council leaves the room. We certainly appreciate, although I know you didn't have much of a choice, but we appreciate the traveling that you all do for us to be able to take the court on the road. So thanks for helping us do this.
Thank you, Chief Justice. May it please the court. I'm Christopher Regan on behalf of Robert and Chastity Smith and their daughter Aspen Smith, who is deceased. Aspen Smith was a full-term, healthy baby when she went to Cabell Huntington Hospital in June of 2014, needing nothing more that day but delivery into the world. Her mother, Chastity, was induced to have labor and labored uneventfully for several hours, with all of Aspen's vital signs being good during this time. However, at about 3:17 in the afternoon, the day that Aspen was born and also died, an intrauterine pressure catheter was inserted by Dr. Clark, one of the appellees in this case, into Chastity Smith and returned blood, the first sign of blood during the course of Chastity's labor. That was a sign, and Dr. Clark conceded that she knew it at the time to be a sign of placental abruption. Placental abruption is an obstetric emergency wherein the placenta detaches from the inside of the uterine wall and thus deprives the baby of its source of oxygen. So effectively, after a placental abruption, the baby is underwater and has to be delivered emergently because even though at the time of birth we are incredibly resilient compared to what we are now in terms of effectively holding our breath, babies can't hold their breath forever. And so this abruption having occurred, Aspen needed to be delivered into the air, the oxygen, so that she could live. The first thing that Dr. Clark did after the IUPC returned blood was leave the delivery room for 10 minutes for an unspecified reason, but not to see any other patient. When she came back 10 to 15 minutes later, she began a 30 to 35 minute process of futilely, repeatedly, and without hope, attempting a forceps-assisted vaginal delivery of Aspen Smith. During this extensive delay, Aspen Smith, asphyxiated, sustained intolerable, unsurvivable brain damage, and when a C-section was ultimately called for at about 5 minutes to 4, it was much too late. Aspen was delivered without tone or APGAR scores above 0 and died not long thereafter. The case was tried in Cabell County against the hospital and the doctor for the failure to take emergent action to protect Aspen Smith's life, and resulted in a defense verdict. Several errors contributed to this verdict, which was against all weight of the evidence in the case. The first and perhaps the most patent and clear was unambiguous disregard of this court's decision in Yates on the multiple methods of treatment instruction. The multiple methods of treatment instruction is in a category near but not all the way to the mistake of judgment instruction that this court has disallowed entirely, and basically allows a doctor to defend conduct on the grounds that, well, there's more than one way to treat a certain condition. Here, the circuit judge allowed that method to be defined at such a high level of generality that the plaintiff's position became impossible. To wit, the multiple method was simply proof that vaginal births occur in the United States. And the Yates court required a defendant who wants to use the multiple methods instruction to produce extrinsic evidence that the method the doctor is defending on is appropriate under the circumstances, meaning evidence from medical journals or treatises, so that the jury and everyone can be assured that it is not just the defense expert who believes in this multiple method. But the defense just didn't do that. They just skipped that part, which is expressly required under the teachings of Yates, and the court allowed that instruction to go to the jury. And indeed, even in this court, you'll see on page 11 and 13 of Dr. Clark's brief, this statement, the plaintiff never proved that vaginal births are not an accepted method of having births in America. Well, of course we didn't. Nobody can prove such a thing. That wasn't the issue in the case, whether we do both C-sections and vaginal births in America. The issue was whether this procession to C-section was unduly delayed. And by allowing the multiple methods instruction in violation of Yates, the plaintiff is presumptively prejudiced under the teaching of Yates, which says that giving an instruction like that when it's not warranted presumptively affects the jury's verdict. So on that ground, a new trial would be called for. Another significant and very striking evidentiary error in the case was the exclusion of the testimony of a witness named Dr. Ratcliffe. Dr. Ratcliffe was a chief of obstetrics at Cabell Huntington Hospital who investigated the matter and determined that this was negligence, in his view, on the doctor for delaying so long, and also on the nurses for failing to activate the chain of command to bring in someone else who would take strong action on behalf of Aspen Smith during this obstetric emergency. His testimony was excluded completely from the case.
Wasn't Dr. Ratliff's information on this case obtained under a peer review process that is absolutely excluded, private, closed?
We don't think so, Justice Hutchison, because if it was, I would never have learned about it. Rather than him testifying to it openly in deposition and revealing it, the defendants would have objected on the grounds of peer review and prevented Dr. Ratcliffe from sharing what he knows. But because he apparently did not learn it during the course of any peer review, no such objection was made. And Dr. Ratcliffe disclosed his view of the matter. And peer review only appeared really for the first time in any discussion of this after the fact as an effort to save that issue on appeal. But that's an incredibly compelling, among the run of medical malpractice cases, most often it is simply the plaintiff's expert versus the defense's expert, both hired and retained people who are subject to cross-examination. You were hired by the lawyer to testify in this case. Dr. Ratcliffe was an unbiased witness, or even one who you would think would lean a little bit towards Cabell Huntington, where he worked. And for him to have that view and have that evidence taken away from the jury because it was cumulative of the retained expert just doesn't make any sense. When witnesses come from two totally separate perspectives, their testimony cannot be considered to be cumulative.
You obviously impassionedly articulate that Dr. Radcliffe would have certainly bolstered your case, but you had a choice. It was your decision on whether or not to put forth as your expert witness Dr. Roberts or Dr. Radcliffe, and you made a choice, did you not, to put forth Dr. Roberts? And you could have put forth Dr. Radcliffe had you so chose. Could you not have?
Absolutely, Justice
So you
Jenkins.
made a strategic decision, and you don't have qualms with the trial courts limiting to ensure there's not duplicative testimony, the number of expert witnesses on each side.
It's only that last part where we disagree, Justice Jenkins, with the way you state that. We do absolutely disagree that the court should limit you to only one witness on a subject when you would have two witnesses coming at the issue from a totally different set of approaches and biases. For example, and when you say we made a choice, the court made us make that choice. But the error that we're assigning today is that we should not have been required to make that choice. The jury should have heard both Radcliffe's perspective and Roberts' perspective. I mean, it doesn't really create the possibility that you're going to have 20 or 30 or, too many doctors to conduct the trial. In fact, Radcliffe's testimony was proffered and it only took, I don't think it even took an hour. So it wasn't going to overly burden the trial for the jury to hear that not only the retained expert, who's always subject to that attack, but also an objective representative of the hospital believed this to have been a case of negligence. And so we don't think the court should have put us in the position of picking one or the other. But in any case, that allowed the defendant to do certain things, like specifically to say to the jury that only one person could be found who would testify that Dr. Clark had done something wrong here. Well, I mean, that just wasn't true. We had found more than one, but we were precluded by the court's decision that there could only be one witness from giving the jury the full picture, and that's highly prejudicial. An additional error that we think is very significant has to do with the testimony of Nurse Spears. When Dr. Roberts, who Justice Jenkins mentioned, testified about his opinions, he did say that he believed that Dr. Clark had deviated from the standard of care, and he added also he thought the nurses had deviated from the standard of care. That resulted in the plaintiff's nursing expert, in a case of nursing negligence, being stricken entirely from the case and not allowed to testify at all. We could not find any case where any such remedy had been granted in West Virginia or anywhere. When a witness says a little bit more, a small statement, and even an unsurprising one, that anybody would have thought Dr. Roberts would have that opinion, it's routine for trial judges to simply say, well, we'll strike that, you're going to address the doctor, somebody else is going to address the nurse, and move on. The sanction of removing an entire witness from the case on whom the plaintiff had opened for Dr. Roberts' 10 additional words of saying what everybody knew he thought anyway, and which was not an inadmissible thought or a prejudicial thought, was totally out of proportion. So even though decisions like that are reviewed for an abuse of discretion, we submit that it is classic abuse of discretion to impose a drastic remedy unknown to the law or any case of this court or another, and totally out of proportion to the situation. Obviously, when you're doing a nursing negligence case, you need your nurse to come in and explain to the jury what your side says the nurses have done wrong. And to take that away was too much.
Again, looking at the transcript, it's my understanding that in front of the judge, you were asked whether a limiting instruction should be given or whether striking the expert would be more appropriate. And it's, from my reading of the transcript, you ultimately stated that the physician was capable of offering an opinion with regard to the nursing staff.
We stated that if Nurse Spears was taken away, to which we vigorously objected, we would have Roberts continue just on the fly and elaborate on his statement that he had made. But that still doesn't change the fact that we have no nurse, that we've promised the jury an opening that we're going to have explain the nursing issues, and it doesn't change the fact that you're unable then to prepare your witness to talk about an issue. You just have to go with it on the fly because out of the clear blue, a witness has been taken away for just this stray remark. And it was significant in relation to that the defendants did it too. They had one of their nurses get up and say they thought the nurses had done a great job, who wasn't one of the experts. And we said, well, sauce for the goose now. And the court just said, no, limiting instruction, and moved on.
And in the transcript, did you not acknowledge or suggest to the court that it was within the court's discretion, the judge's discretion, as to which approach they would take?
I mean, it is only in the sense that it is a discretionary ruling of the court, not in the sense that such a decision would be correct. I mean, we did vigorously object to the decision.
One thing that bothered me, is it accurate that after this ruling was made, they still let the other side kind of hammer the obstetrical expert that he didn't know anything about nursing?
Right, right. I mean, quite skillfully, and in being zealous for his client, Mr. Offit and Mr. Craig, absolutely hammered Roberts for, well, you're not a nurse and you haven't been nursing, and you really shouldn't be talking about what these nurses have done or not done. And meanwhile, we have a fully prepared, appropriately qualified, deposed nurse hired in the case. She had actually flown from Los Angeles. She was at the Pittsburgh airport getting ready to drive down to Huntington to testify when this ruling came down. And it was a shock to the case, and we just can't find any precedent for such a drastic remedy. The only times experts get taken out of medical malpractice cases like that is when they're undisclosed, when nobody has said that they were going to testify at all, and it's a matter of pure surprise. Just one stray line by Roberts should not have taken away the nurse from the plaintiff's case. We also saw in the case a number of evidence which, under the Graham case, as we explained in the brief, was just irrelevant to the case. There was an entire pathologist witness, an additional expert, called by the defendant to inject into the case Chastity Smith's prior miscarriages, a protein S deficiency, or MTHFR, blood deficiency. A reference attempted to be made to her Chastity's mother's miscarriage, and other things that on cross-examination the expert could not connect to any issue of liability or any issue of damages. In other words, none of those things were alleged to be the cause of Aspen Smith's death. Everybody agreed that Aspen Smith died of not having been sooner delivered. Even the defendant's expert said that. And this pathologist, Salafia, couldn't give any connection of all that mud sort of thrown at Chastity Smith and her family history and these miscarriages to the case. And under the Graham case, that's not supposed to be allowed. The court has to do a gatekeeping role on expert testimony and make sure it goes to a live issue. And what the defendant simply said was, well, we want to give the whole picture, which is kind of a classic trial lawyer tell for we don't have a correct purpose for this evidence. So they just say, well, we wanted to give the whole picture. But it had nothing to do with the case, and therefore it should not have been allowed. The standard...
The jury never got to the issue of causation, though. And so this testimony would have related primarily to that issue, would it not? But the jury never got to that.
I think that's right, Justice Jenkins. I mean, if Salafia's testimony was relevant, it would have been to causation. But of course, it wasn't relevant to anything. And so what we contend under the Graham case was it just kind of confused and muddled all the issues. And under Graham, the court applied a standard of if that kind of evidence comes in, that kind of expert evidence that can be particularly difficult for a jury to handle, the burden should really be on the introducing party to show why it didn't affect the verdict. And so ultimately, if the jury was led to believe by all that irrelevant evidence that, well, maybe this was all just caused by something else, then that could also explain their decision that this is not a plaintiff's case. And so we think that Graham can't afford the plaintiff relief under that. We had a fairly routine decision in the case that Dr. Clark would not be confronted with other malpractice cases against her in this case. And you see that all the time in medical malpractice. But where that ruling got taken too far was when Dr. Clark contradicted some of her prior sworn testimony from one of those cases. Because anybody who is testifying, whether or not they're telling the truth is one of the main issues for the jury to consider. And when you contradict your prior sworn testimony, you're subject to impeachment. But when we attempted to impeach Dr. Clark with her prior testimony, the court extended its ruling out to say that, well, because Dr. Clark has excluded evidence of any prior malpractice cases she's been involved in, she also can't be cross-examined with any of her prior testimony, because the jury might think, well, there's another deposition, so there's another case, so there's other malpractice, and that might prejudice against them, against Dr. Clark. That's going too far. Everybody is bound by their prior sworn testimony and the process of impeachment that is used to test whether we are telling the truth. And even if your prior case isn't going to come in, and we weren't going to come in and say, well, this is malpractice in this case because Dr. Clark committed malpractice in another case. But if you contradict your prior sworn testimony, though, you have to be accountable for that. Every other medical witness was cross-examined with depositions from their prior cases because it's a very common thing. But the trial judge went too far in protecting Dr. Clark, in excluding her prior deposition testimony and impeachment of her, simply because it didn't want the jury to know she had ever been sued for malpractice in the past.
Was the ACOG bulletin that she testified to in the previous medical liability claim a similar issue that was at issue in this case?
The similarity of the issue was that in the prior case she had said, I'm not bound by that ACOG stuff. I'm the doctor, it's my decision. If I think it's right, doesn't matter what ACOG says, I can do it my way. Whereas in this case, she was using ACOG as a shield, having her expert say, well, no, ACOG has a guideline and I'm within it, so I'm okay. So what we wanted to illustrate to the jury was that there was a little bit of unfairness there to use ACOG as a shield on one occasion, but then say you're not bound by it when it hurts you. But most importantly,
was this case a breech birth? Because that's the ACOG bulletin that she had testified to before that you wanted to try to impeach her here. It was relating to a breech birth. That's not the issue here.
That's right. This was not a breech birth. And the issue was at a higher level than that. It was basically what was most important was that Dr. Clark was asked, have you said in the past that you're not bound by the ACOG standards? And she said no. But in that breech case, she had said, I am not bound by the ACOG standards. And so what was important was not what the nitty-gritty of that case was about, but that she had contradicted herself. And that's what we thought we were entitled to show the jury so they could evaluate her credibility, but the judge did not allow that. And we feel that goes too far. If every defendant in a malpractice case is insulated from all their prior testimony, just because that might hint at prior cases, that gives them too great an advantage over every other witness that has to deal with their prior testimony, whatever it might be. I do want to talk a little bit about that ACOG, though, on the other ACOG standard, Justice Jenkins, about the 30-minute rule, because the standard of care is what would a reasonable doctor do under the same or similar circumstances. That's over here. The 30-minute rule that ACOG gives out is a rule for facilities that basically says if you can't get all the people necessary to do a C-section within 30 minutes, you ought not advertise yourself as delivering babies. And this occurs primarily in rural settings where they don't have 24-hour anesthesia coverage or enough obstetricians to cover it. But instead, in this case, that direction from ACOG, which is not automatically a standard of care, it can be evidence of a standard of care, which is for facilities, got twisted into the idea that any C-section that occurs within 30 minutes of it being called for is standard of care, is okay. They like to say, you got it within the 30 minutes. But that's not what the rule's about at all. The undisputed evidence in this case was that the standard of care required Aspen Smith to be delivered as soon as possible. And that could only be done by a C-section because of the undisputed evidence in the medical record that Chastity Smith was never completely dilated, and so a forceps delivery was futile. And even giving the benefit of the doubt to Dr. Clark's testimony that at some time when nobody noted it in any record, she was briefly complete, it still would not justify 30 minutes, repeated attempts to futilely deliver this baby through a vaginal approach when Aspen Smith could have been saved with a C-section at any time. In fact, even the defendant's experts admitted that had Aspen Smith been delivered just 5 minutes earlier, had it only been 25 minutes of delay instead of 30 or 35 minutes, Aspen Smith would be alive today, looking forward to her third birthday. So,
Well, with that, we've given you a little extra time because there are a lot of issues in this case. You can be sure that we have reviewed everything very thoroughly, even if it's not discussed. I'm going to turn it over to the other side, and I'll allow brief rebuttal for you at the end.
thank you, Chief Justice.
May it please the Court, Chief Justice Walker, D.C. Offutt for Dr. Clark. I'd like to start by just giving you a brief overview of the facts of the case. Mr. Reagan is off by a couple of hours in his timing, but the sequence is correct. I think he said 3:17. It was actually 5:17. The IUPC, which is a device that measures the pressure inside the uterus when there's a contraction, was placed by Dr. Clark. It has a very soft, pliable rubber tip. In all of the literature in OB/GYN history, there's never a case been reported where an intrauterine pressure catheter caused a placental abruption. Mr. Reagan said blood was returned in the catheter. There was pinkish fluid returned in the catheter. Dr. Clark recognized that as a potential hidden placental abruption where the bleeding is behind the placenta, is not coming out. She recognized it was a potential medical emergency. And about 5:35, she began the process of delivering the infant. The multiple methods of treatment in this case where you could deliver the infant as quickly as possible, either by vaginal delivery or by C-section. And both experts, Dr. Roberts and Dr. Manning, testified that either method was appropriate. Dr. Manning, Dr. Clark's experts, one of the pioneers in obstetrics and gynecology. He developed most of the fetal heart monitoring techniques used around the world. He developed a test known as a biophysical profile that's performed millions of times a year around the world to assess fetal well-being. Dr. Manning described this as a well-seasoned, very experienced obstetrician who was cool and calm under the circumstances, who felt that she could deliver this baby most quickly vaginally. She made that attempt, and when it failed, it took her 6 minutes to do a C-section and deliver the infant. So Dr. Roberts agreed with that. He said, I don't agree with you the facts, but assuming that Dr. Clark felt that she could to deliver this baby vaginally quicker than doing a C-section, that's within the standard of care. So
If both methods of delivering a baby are so widely accepted, why
Correct.
did you need a multiple methods instruction?
Well, because they were implying that Dr. Clark had to immediately go to a C-section, that this option of vaginal delivery was basically a violation of the standard of care. So the multiple methods was so the jury would understand there's not one way that's accepted within the standard of care to approach this medical emergency, but there are two methods, and their expert agreed with us in that regard. So I don't think we needed extrinsic evidence. We had evidence in the form of two ACOG, board-certified obstetricians who testified that that was within the standard of care.
But wasn't the factual issue in this case whether she was fully dilated or not?
It was, and Dr. Clark testified that although there was nothing in the record that documented dilation beyond 9 centimeters, that she was able to determine that she was fully dilated in her examination, and she actually was able to place the forceps inside the vagina around the baby's head, but she couldn't articulate the forceps, put them together and apply traction. So she took the forceps out. The medical evidence was you can't do that if you're not fully dilated. So there's extrinsic evidence of that, the fact she was able to place the forceps, and her own testimony, and she's the only one who was there doing the vaginal exam, at the foot of the bed who would have known that, and the experts all agreed with that.
What was the court's reason for excluding the nursing expert witness?
That Dr. Roberts testified that opined on nursing. That there's a long, we should go back a little bit. This case was originally Judge Husted's case. She entered an order early on the case that each side could have one expert on the issues. The plaintiffs continually added experts, supplemented experts. They needed a placental pathologist. They had not 2 OB experts, they had 3. They also, in addition to Dr. Roberts and Dr. Radcliffe, they named a Dr. Bianco from New York. So
Well, what about the nursing expert?
The nursing expert was added late. They were permitted to add her. She, of course, was only testifying as to the hospital, and I'll let Mr. Craig address that. But Dr. Roberts weighed into that, said he knew all about nursing. His wife was an obstetrical nurse, that he had taught nursing, and he was allowed to fully explain.
But didn't you cross-examine him, or whoever was conducting the trial, to the effect that you're not a nursing expert?
I wouldn't have done that. Mr. Craig would have done that.
Well, whoever was, it
Yes.
doesn't matter. But
Right.
in other words, they were.
I would have said,
Well, I just am asking, didn't someone cross-examine him after the expert nurse witness was excluded and say, hey, you don't know what you're talking about, do you, on nursing expertise?
Yes, I recall that, and I recall him arguing back that his wife was an obstetrical nurse and he had taught nurses and he was fully qualified to be critical of the nursing care. Yes. So on the Dr. Salafia, who was the placental pathologist, as I said, the plaintiffs named a placental pathologist, Dr. Schwartz, who they did not call. They were allowed to call a rebuttal placental pathologist to rebut Dr. Salafi's opinions, but Dr. Salafi's opinions were kind of unique in this case because the plaintiffs brought up a study by an individual named DeYoung, which looked at babies who had undergone a complete placental abruption, that is, a complete abruption of oxygen transfer from the placenta to the baby. And that study concluded if those infants were delivered within 18 minutes, the vast majority did fine. If they were delivered after 18 minutes, some did fine, some died, some had major medical problems. So the plaintiffs argued, in effect, that the standard of care required Dr. Clark to deliver this baby within 18 minutes. Dr. Clark herself was very upset about the outcome of this case and did not understand why this baby had no reserves and basically was born with 0 APGARs, born lifeless, and never recovered at all. What Dr. Salafi explained from the examination of the placenta is this was not an acute abruption, but a chronic process that had been going on for several days. In other words, there was bleeding. And that had affected the baby and the baby's reserves, so that even though the baby was timely delivered, it simply didn't have the reserves to bounce back in resuscitation. And that was the importance of Dr. Salafi's testimony, and that's why it was relevant. As I said, they were allowed to call rebuttal pathologists who testified before the jury and gave contrary opinions. The jury decided that factual issue, or never got to that issue really, although it did help to explain why this baby did not bounce back because the NICU team was there. They immediately resuscitated the baby, did all the standard protocols under neonatal resuscitation, but the infant never responded in the least. The ACOG bulletin, in most cases, you file a motion that, other lawsuits on behalf of the defendant not come into evidence. The judge says, granted, that's the end of it. In this one, we had to produce detailed information about every case that Dr. Clark had ever been named a defendant in, and most of them were cases where she was named with her partner, Dr. Bruce Radcliffe, where she had done nothing wrong and had eventually been dismissed. But anyway, we went through all those cases and actually had a 404B evidentiary hearing prior to the trial, went through them all. Judge Howard made the decision in each individual case as to whether it was relevant or not. The plaintiffs manufactured this ACOG argument to try to entrap Dr. Clark and impeach her. She never mentioned ACOG in her direct exam. She never said, I'm relying on the ACOG 30-minute delivery. Dr. Manning said that a 30-minute ACOG bulletin does not allow Dr. Clark to take 30 minutes to do the delivery. She still has to do it within a reasonable period of time, and she did. So by trying to go through the back door, they tried to back her into saying, oh, well, you don't believe in the ACOG opinions. And Judge Howard appropriately cut that off because in his discretion, he felt that was going to bring up other lawsuits in which Dr. Clark had been a defendant. We would have then had to put on evidence about that case.
So
and
you're
what
saying
happened.
there was not inconsistent testimony by the
There
doctor?
was not in this case because she never.
No, I mean, if you compare prior sworn testimony to what she testified to in this case, was there an inconsistency?
I didn't go back and look at the other case. It was a deposition. It wasn't a trial. It was a breach delivery. It was a different kind of case, and she may have said something about the effectiveness of ACOG bulletins. But in this case, she never said, I'm relying on an ACOG bulletin.
So you're saying there was no inconsistency?
There was not, absolutely. The 30-minute standard of care, we've brought that up as a cross appeal. Dr. Roberts tried to use that kind of in the reverse to imply that we had a higher standard of care because Cabell Huntington had a level 3 NICU, had round-the-clock obstetrical care, had round-the-clock support for deliveries, and therefore at Cabell you had to do it faster than in Dr. Roberts' colloquialism in Cupcake, Tennessee. And so we argue that he basically was trying to impose a higher standard of care upon Dr. Clark and the obstetrical nurses in this case, and thought that was error, and we've brought that up as a cross appeal. Of course, that's moot should you affirm Judge Howard's rulings in this case.
Did you object to the Cupcake, Tennessee reference?
We did. We did. Unless there are any questions, I'll just say that I've tried many of these cases, probably more than 25 obstetrical cases. They're very difficult. They're very complex. This was Judge Howard's first civil medical malpractice case. I think he did a wonderful job. He was fair to all sides. He was thoughtful in his rulings, and I believe that his decision should be affirmed.
Thank you. Now, Mr. Craig, for the benefit of those in the audience that may not be familiar with the case, Mr. Offutt represented the physician at trial, right?
Correct.
And you represent the hospital, in other words, the nursing
Correct.
that took place, right? So could you start out by answering Justice Workman's question about the nursing expert?
Gladly, Your Honor. The background here is deep, and you need to understand it in order to understand completely why the trial judge ruled as he did. First, the petitioner disclosed timely Dr. Roberts, and Dr. Roberts was disclosed as a witness, an expert witness, on both the physician standard of care and the nursing standard of care. Dr. Roberts was deposed, and at great length questions were asked and answered regarding nursing in the case, what the nurses had failed to do, in his opinion, as it related to the assessment of the status of the delivery, the timing of the delivery, and whether or not the nurses should have climbed the chain of command as it relates to the decision Dr. Clark was making. Dr. Bianco was next identified by the plaintiffs in a non-timely basis and was disclosed as a physician who would have testimony critical of the nursing care. Dr. Bianco was deposed, and she did not have criticisms of the nurses in the case. Next came by the plaintiff in September of 2016, a third witness, Dr. Burroughs, who was disclosed as a witness who would have testimony critical of the nursing care, and Dr. Burroughs' deposition was never taken. Finally, a year later, Nurse Spitry was disclosed as a nurse who would have criticism of the nursing care. At that time, we filed a motion saying there are too many witnesses being disclosed here on the issue of nursing negligence, and we think that we should be allowed to only have one witness against which we must contest. And the court agreed. In both pretrial conference and the 404B evidentiary hearing that took place, the judge adamantly said, there are three parties here. They're standard of care witnesses, experts. They're causation experts. You folks only get one. You all have trial experience. You know that that kind of effort is made by trial courts in order to keep issues clearer over the course of an 8-day trial. So the admonition had been clear. Pick one. And the plaintiffs in this case picked, despite our objection as to the timeliness of it, Nurse Spitry. Well, fast forward now to trial. You have an opening argument in which Dr. Roberts is revealed as a fetal medicine expert who's going to testify. You have a CV presented in his testimony in which he at length explains his background, both as it relates to physician care and nursing care. And then you have a declaration by him that he is there for purposes of criticizing both the physician and the nurses at Cabell Huntington Hospital who deviated from the standard of care in this case. That's the rung bell that we refer to in our briefing. That's the bell that can't be retracted. The jury has heard that. And we objected, saying, Judge, you previously ruled that everybody gets one, and now we're being told, the jury's being told, that the doctor has an opinion as it relates to the deviation. Yes, there definitely was one. And a nurse is going to be following who's going to be testifying as well. That countermanded all elements of fairness that were extant in the case at the time. The judge made a ruling saying that that bell had been rung, knowing full well that the deposition of the doctor had been taken. There was no prejudice whatsoever because his position was clearly known and had been extolled in that deposition. Therefore, him having testified as he did, the judge went on and ruled that he should be the party, the expert witness who testifies against the nurses. Yes, Justice Workman, we did point out that he's not a nurse. He certainly can testify as to the standard of nursing care. We didn't challenge that. But if you're going to criticize nurses for failing to activate the chain of command, we contended to the jury, you need to be a nurse in understanding that issue from a nurse's perspective.
Well, they had one, though, didn't they? And they wouldn't let them use it. They had a nurse.
They had an expert nurse who was not being called in view of the fact that their witness said, I'm going to testify against the nurses, and the judge ruled, okay, you'll be the one to testify.
Okay. I got you.
And that's how the whole matter unfolded. Now, the petitioner has suggested that a curative instruction could have cured this whole thing. Could it have? Could it have? They use a curative instruction during the course of a trial as an example of how curative instructions can heal things. And they're right, it did in that particular episode. A floor nurse, Mary Murphy, stated that she thought the use of forceps was the quickest way to delivery. Objection from the plaintiff. Outside the hearing of the jury, the judge said, ma'am, you're getting a little close to opinion testimony here, and you're a fact witness. So I want to encourage you not to express opinion and to limit yourself to the factual evidence that you have knowledge of. Jury brought back in the room. Judge says, disregard the nurse's statement regarding the fastest way to delivery, and the case moved forward. Compare that to the circumstance which evolved at the beginning of trial, where you had the expert witness, his credentials being carefully and thoroughly reviewed, his CV being paraded in front of the jury, and he states unequivocatingly these, quote, 10 little innocent words, I'm here to testify against Cabell Huntington Hospital's nurses. Oh, that's a stray remark. Oh, that's just an inadvertent slip. Well, the judge said, hardly, and the judge was right. Now, if there are no more questions on that one, I'd like to move on to a couple of different issues.
Go right ahead.
Thank you, Madam Chief Justice. Dr. Salafia, the placental pathologist, was shared expert. Plaintiff has criticized her, saying that there's no nexus between her testimony as to the status of that placenta and the delay in delivery. Well, she's not there as a standard of care expert. She's there as a causation expert to explain what happened in this case. And she so stated that what happened caused the unfortunate death of the infant here. That's the nexus testimony she needed, and she gave it. A very poignant point in the trial occurred when Dr. Clark was on the stand and testified that she was just bewildered after the delivery of this infant as to why the infant's reserves were so low. And upon delivery, was able to discover the concealed placenta and the clotting problems that had occurred. In this case, Dr. Salafia testified, some 48 hours prior to the commencement of labor, which means that Dr. Clark had no way of knowing that there was bleeding going on for this infant in utero, and therefore couldn't have had any idea as to the depletion of that child's reserves during the course of the labor and delivery. Now, that's not testimony that the petitioner wants to hear in this case. And so he says she should be excluded because of the lack of nexus on the standard of care issue. But it was this express witness who was able to explain to the jury under Rule 702 why Dr. Clark was so bewildered and perplexed about the lack of reserves that existed for this child. Her testimony was vital to the defense. There's absolutely no process defect in it. And that testimony, while radically charged by the petitioner as being something they don't want to hear, is nevertheless something that the jury needed to hear in order to explain Dr. Clark's conduct. The 404B hearing on the issue of the 18 cases that plaintiff attempted to introduce in this case to impeach Dr. Clark was long, involved, and detailed. The Sizemore case, Justice Hutchinson, you are absolutely right, dealt with an ACOG issue as it relates to a breach. The circumstances of that deposition, and it was just a deposition, it was not a trial, were first of all called on by the trial court to be irrelevant to the matter at hand. Now here's an appealable issue, Your Honors, and it's a question you may choose to address. If a trial court has, in a detailed 404B hearing, determined something, anything, to be irrelevant, can that wall, if you will, that's been constructed be knocked down in order to satisfy the goal of impeaching a witness? I say to you, no. I say to you, after a 404B hearing has occurred, even when the goal is to try to impeach the witness, if an informed decision has been made by the trial court that relevancy is not contained in that challenge, impeachment oriented or otherwise, then it's done.
Well, relevancy is not really the consideration in the context of impeachment, is it? Impeachment is for the purpose of trying to demonstrate that the witness is not either being truthful or lacks credibility, and not the substance of the issue.
Well, and I agree with you, and I think Mr. Offutt was agreeing with you when he said we don't find that there was a challenge to be made of Dr. Clark on this point.
Well, if there's no inconsistency, then you have no problem. If there is an inconsistency, you might.
We agree. And in this case, there wasn't.
Well,
Well, did the judge make a 403 analysis?
Oh, I think so.
You think, or did he? I don't mean-
Yes, he did.
Okay, thank you.
Let me talk about Dr. Radcliffe, and then I'll quit, Madam Chief Justice, in the interest of time.
Sounds like a good plan.
There was a peer review hearing very early on in this case. There was a peer review determination made that that peer review information would not be disclosed, as is the law in the state of West Virginia. The problem that the plaintiff then had was Dr. Radcliffe had talked to the family. I don't know why Dr. Radcliffe chose to do so. I'm sure it was out of concern and compassion over these very difficult circumstances that had arisen for this family.
Well, did he treat the mother after the birth?
I believe so.
Well, that would be
Yes, I believe
probably
that's
a
the case.
reason.
And that's
Only on one occasion, right?
right,
Okay.
right.
Right, okay.
But the issue is that any peer review information that he had couldn't come forward. The sympathy that he was expressing, therefore, is arising in his capacity as a doctor, and the plaintiff had the option to use him as their expert if they wanted to do so. Justice Jenkins, you're right on point in pressing the petitioner on this very issue.
Well, was he strictly going to be an expert, or did he also have some facts to testify?
Well, he may have had those facts as well. But the point is that he couldn't also bring the opinion testimony that the plaintiff wanted to bring, and therefore the plaintiff chose to bring Dr. Roberts instead. One last thing I guess I would like to say, Madam Chief Justice, if I may. There's a way to the argument being made at the conclusion of the petitioner's case. And I want to tell you that the moment of truth in this trial over the issue of whether or not, Justice Walker, she was fully dilated, occurred in the trial. There's a hole in the medical record, and so many of these medical malpractice cases exist because plaintiffs persist on trying to take advantage of a hole in the medical record. But there was no hole in what was happening factually. It was Dr. Clark who had her hands inside the vagina and was able to make the determination that completeness had occurred. And she said to that jury, I made the decision based on how matters were developing. I had my hands there. I knew what was happening. You didn't, Mr. Plaintiff's Counsel. You can challenge my decisions all you want to on the basis of the hole in the medical record, but I know what happened. And the jury believed her. And that's the greatest weight argument that any appellate court can hear. Thank you very much.
A brief rebuttal.
Thank
I
you.
know there are many issues, so
I just want to hit a couple of them fast. The first one being that there's no hole in the medical record at all. The medical record unambiguously said, even in a record that Dr. Clark prepared the next day, that chastity was 8 centimeters. There's nothing missing. There's no hole. The testimony was in contradiction of the medical record's express statements, not about something that was just excluded. On Yates, they have nothing. They have no extrinsic evidence. Extrinsic evidence is not Dr. Clark talking about something she saw that's extrinsic to her. It's extrinsic evidence of the standard, of the method that she used. They never introduced any, and that fails Yates unambiguously. In respect to Dr. Salafia, I'm a little bit beside myself. Dr. Salafia repeatedly disclaimed that anything that she found, other than the asphyxiation due to the major abruption, caused the death of Aspen Smith. She never said that Aspen Smith died of lack of reserves. It was because of that she was not a causation witness. Those references are collected at page 13 of the petitioner's brief. Manning was their causation expert, and he said Aspen Smith died of asphyxia because of the major abruption and would have been saved had she been delivered 5 minutes earlier. If Salafia was testifying on that too, they'd have been in violation of the all-important one expert per issue rule. But Salafia couldn't say that. All she could do was talk about what she perceived to be various weaknesses that did not connect to the issue. That's why that evidence failed Graham. In respect to Dr. Spear, the evidence, the history of the expert disclosures is not at issue. There's no Rule 16 issue before the court. Nurse Spear was our expert on nursing. She was wrongfully taken away, and they fully capitalized by the way they attacked Roberts on that. I mean, if one expert is what you get on an issue, and you think the plaintiff ought not have had two, well, surely zero is not fair. We disclosed.
If I can just interrupt for a moment on that issue, what would you, other than the fact that they impeached Dr. Roberts in terms of not being a nurse, and I know you've already made that argument, what would you have obtained from the testimony of Nurse Spear that you didn't get? That's what I guess I'd like to know what your explanation is. What would you have gotten from that testimony that you did not get through Dr. Roberts?
Thank you, Justice Thompson. The precise head-on answer to what Mr. Craig just said, when he said, if you're here criticizing a nurse, you better be a nurse. I mean, that has real jury appeal and resonance. And that's why we had a nurse. And when that was taken away, that's a brutal blow to the plaintiff's case. And the main point, of course, is that taking it away doesn't measure up to the law. It's just too extreme a sanction for Roberts letting on that, in addition to thinking that Dr. Clark breached the standard of care, yeah, of course he thinks the nurses should have done better too. It's just way out of proportion, and that's what an abuse of discretion is all about. I want to end on that peer review thing because I think it's important. Dr. Ratcliffe was not excluded because of peer review. He disclosed that information, and it was available to anyone to use. He was only disallowed because they thought it would just be too much evidence for the plaintiff. And that's not a rule of evidence, that the plaintiff has too much evidence, as long as that evidence isn't repetitious. And Dr. Ratcliffe, I think as we've pointed out, isn't repetitious because it comes from a totally different place. So peer review, they didn't make any showing of peer review as to Dr. Ratcliffe. And there would be evidence of record if they did, and you will find that there is not any. So, you know, for all those reasons, I want to say on behalf of Robert and Chastity that this was a terrible, terrible loss that they suffered. And they've carried this case very far so that this doesn't happen to any families in the future. This 35-minute delay, it's egregious. It was much too long. And so that this doesn't happen again, a fair opportunity for them to prove their case needs to be allowed with correction of the errors that have been elucidated today. And with that, I thank the court for its kind attention and to bring us here to Morgan County. Thank you.
Well, thank you. This case will be submitted. I'll note for everyone in the audience, the students and our guests, that you've seen 5 excellent lawyers arguing today, and a really good example of what we get to do all the time in Charleston. And now, to the clerk, I understand we have an emergent matter?
Yes, we have a third case added to the docket today. The case is In re Flat Stanley. It's here under the court's original jurisdiction, brought by the Honorable Deanna Rock, family court judge, on behalf of her godson. And so, Chief, if I may Flat Stanley approach the bench for a photo op?
Yes. All right. So how does this work?
Coming close to that.
Yeah, coming closer.
Are we going to question him or anything? Let him have what he wants.
Somebody got to swear at him. Good.
All right. Thank you, sir. Flat Stanley has to go back to the envelope. Oh, no, you want some?
I have this.
Okay, all right. All right. All right, now.